Rule 107, Absentees, Section 1, Appointment of Representative. When a person disappears from his domicile, his whereabouts being unknown, and without having left an agent to administer his property, or the power conferred upon the agent has expired, any interested party, relative or friend may petition the court of first instance of the place where the absentee resided before his disappearance for the appointment of a person to represent him provisionally in all that may be necessary. In the City of Manila, the petition shall be filed in the Juvenile and Domestic Relations Court. Section 2, Declaration of Absence. Who may petition? After the lapse of 2 years from his disappearance and without any news about the absentee, or since the receipt of the last news, or of 5 years in case the absentee has left a person in charge of the administration of his property, the declaration of his absence and appointment of a trustee or administrator may be applied for by any of the following. A. The spouse present. B. The heirs instituted in a will who may present an authentic copy of the same. C. The relatives who would succeed by the law of intestacy. And D. Those who have over the property of the absentee some right subordinated to the condition of his death. Section 3. Contents of Petition. The petition for the appointment of a representative or for the declaration of absence and the appointment of a trustee or an administrator must show the following. B. The names, ages, and residences of the heirs instituted in the will, a copy of which shall be presented, and of the relatives who would succeed by the law of intestacy. C. The names and residence of creditors and others who may have any adverse interest over the property of the absentee. D. The probable value, location, and character of the property belonging to the absentee. Section 4. Time of hearing, notice, and publication thereof. When a petition for the appointment of a representative or for the declaration of absence and the appointment of a trustee or administrator is filed, the court shall fix a date and place for the hearing thereof, where all concerned may appear to contest the petition. Copies of the notice of time and place fixed for the hearing shall be served upon the known heirs, legatees, devisees, creditors, and other interested persons, at least 10 days before the day of the hearing, and shall be published once a week for 3 consecutive weeks prior to the time designated for the hearing in a newspaper of general circulation in the province or city where the absentee resides, as the court shall deem best. Section 5. Opposition. Anyone appearing to contest the petition shall state in writing his grounds therefor, and serve a copy thereof on the petitioner and other interested persons on or before the date designated for the hearing. Section 6. Proof at hearing order. At the hearing, compliance with the provisions of Section 4 of this rule must first be shown. Upon satisfactory proof of the allegations in the petition, the court shall issue an order granting the same and appointing the representative, trustee, or administrator for the absentee. The judge shall take the necessary measures to safeguard the rights and interests of the absentee and shall specify the powers, obligations, and remuneration of his representative, trustee, or administrator, regulating them by the rules concerning guardians. In case of declaration of absence, the same shall not take effect until 6 months after its publication in a newspaper of general circulation designated by the court and in the official gazette. Section 7. Who may be appointed. In the appointment of a representative, the spouse present shall be preferred when there is no legal separation. If the absentee left no spouse, or if the spouse present is a minor or otherwise incompetent, any competent person may be appointed by the court. In case of declaration of absence, the trustee or administrator of the absentee's property shall be appointed in accordance with the preceding paragraph. Section 8. Termination of administration. The trusteeship or administration of the property of the absentee shall cease upon order of the court in any of the following cases. A. When the absentee appears personally or by means of an agent. B. When the death of the absentee is proved and his testate or intestate heirs appear. C. When a third person appears, showing by a proper document that he has acquired the absentee's property by purchase or other title. In these cases, the trustee or administrator shall cease in the performance of his office, and the property shall be placed at the disposal of whose may have a right thereto.